Hi, my name is Angela Westmacott. I'm a lawyer with Westmacott in Victoria, and we're general counsel for the British Columbia Institute of Agrologists. I've been asked to do a presentation for part of your continuing development on professional negligence principles and on regulatory offences, two areas that are of interest to all professionals. This presentation will cover negligence and regulatory offences, but I just want to start by saying that the conduct of members of a self-regulating profession is supervised internally by its own regulatory body, which oversees licensure of its members and discipline of its members under its Act and its bylaws. So, for example, the Agrologists Act governs the powers that are given to the Institute of Agrologists to oversee who can be admitted as a member, as a member of the Institute and their conduct as members of the Institute. And it has this in common with every self-governing body, such as the College of Physicians and Surgeons, which oversees licensure and discipline of doctors. Self-governing professions always have to exercise their authority in the public interest. So conduct is generally governed by reference to bylaws, practice standards, and codes of ethics. However, and where I want to focus today is on the conduct of professionals that's regulated externally through the courts, through common law principles of negligence, and through regulatory offences that are contained in various statutes that relate to the activities of a profession. So this presentation will focus on external regulation of professionals through negligence law and regulatory offences. I'll start with the concepts of negligence and then turn specifically to negligent misrepresentation, as most claims, or many claims against professionals, are cast as claims of negligent misrepresentation. I'll then talk about the various defenses to negligence claims. I'll then turn to regulatory offenses, what they are and what defenses are available to regulatory offenses, and most notably the defense of due diligence. And finally, I'll end by talking about different strategies to minimize the risk of having a claim of negligence made against you or facing prosecution for a regulatory offense. So negligence is a legal principle that was developed by the courts, requiring everyone to take reasonable care not to hurt or harm others who could reasonably be harmed or hurt by your conduct. So if negligence is proved, a court may award compensation for injury or loss, even where the wrongdoer, the defendant, or also known as the tortfeasor, does not have a type of formal relationship, such as a contractual relationship. So you could have negligence against a complete stranger, or against the operator of another car, or against a professional who's given you services. Really, the application of the principles of negligence are virtually unlimited. The concept of negligence in the neighborhood principle originated in a case called Donahue and Stevenson, a 1932 House of Lords decision, which involved a woman who purchased and drank a bottle of ginger beer that contained a dead snail. The bottle was opaque, so she couldn't see the snail in it before she drank it. She subsequently became ill and sued the manufacturer. She couldn't sue in contract because she hadn't purchased the ginger beer directly from the manufacturer. Rather, as in most cases, the manufacturer sold it to a vendor who then sold it to the purchaser. But the court nevertheless found the manufacturer was negligent and owed the woman compensation for falling ill. And they based that decision on negligence principles, finding that the manufacturer was in a sufficient relationship of proximity to a purchaser that the manufacturer ought reasonably to have known that if they had a faulty product and it was consumed by someone who bought the ginger beer, that they would fall ill. Succeeding in a negligence claim requires the plaintiff, the person who's initiating the lawsuit, to prove 4 elements. And all of these elements have to be proven on a civil standard of proof, that is to say, on a balance of probabilities. The plaintiff must establish first that the defendant had a duty of care to the plaintiff, that the defendant was in a position of sufficient proximity or neighborhood to the plaintiff that the defendant ought to have known that their actions could have caused harm to the defendant. Secondly, the plaintiff must prove that the defendant did not exercise this necessary standard of care in the conduct that they were carrying out. Thirdly, the plaintiff must establish that they suffered some form of compensable harm, whether it's injury or loss of profits, some sort of harm that forms the basis for a damage award if negligence is found. And finally, the plaintiff must prove that the harm that they suffered, whether it's the injury or the loss of profits or whatever shape the harm took, arose from the failure of the defendant to exercise the standard of care, and this is referred to as causation. If all four of these elements are established on a civil standard of balance of probabilities, a court will find that the defendant is negligent and the plaintiff will be awarded damages to compensate him or her for the harm that they have suffered. The standard of care for all of us as members of the public is that of a reasonable, careful person in the defendant's circumstances. However, the standard of care is higher for professionals. A professional automatically has a duty of care to his or her client because there's reasonable proximity. All professionals know that their clients could be harmed if they don't provide proper advice. The standard of care that's applied to professionals is the standard of care of a professional of average competence, i.e. knowledge, skill, and care in that profession. You don't have to meet the gold standard and provide the best possible advice, but you have to provide advice that's consistent with the advice that would be given by a reasonably, knowledgeable, skilled, competent agrologist, or in my case, a lawyer. Negligence claims can be made whether or not the professional has entered into a formal contract with the client, and contracts can be written and verbal as well. Negligence claims can also be made in relation to voluntary work. Even if you've not charged for the work, you can still be sued if the advice led to a loss on the part of the person who relied on it. If there is a contract in place between the professional and the client can sue for both breach of contract for providing, failing to provide the services that were contracted for with the proper standard, and for negligence. I want to turn to negligent misrepresentation because it is one of the most common types of negligence claims against professionals. A claim of negligent misrepresentation can be made when a person reasonably relies on advice or representations from another party that were not true and the person suffers harm as a result. Claims against professionals, as I said, often take the form of negligent misrepresentation. So what are the elements of a claim of negligent misrepresentation? The plaintiff, the person suing the professional for negligent misrepresentation, has to prove these elements, again, on a civil standard of balance of probabilities. First, the plaintiff has to establish the existence of a special relationship between the plaintiff and the defendant, such as a professional-client relationship. If there's a professional-client relationship, there's automatically a duty of care. Secondly, the plaintiff must establish that the defendant provided advice that was untrue, inaccurate, or misleading in some way. Thirdly, the plaintiff must prove that the defendant did not exercise the standard of care that would reasonably be expected by a professional in that field giving that advice. Fourthly, the plaintiff must prove that there was actual and reasonable reliance by the plaintiff on that advice. It doesn't matter if the defendant provided inaccurate advice if the plaintiff didn't rely on it. And finally, again, the plaintiff must establish that he or she or it suffered harm arising from reliance on that advice. So let me give you an example. An agrologist advises a client to use a cheaper pesticide on a crop. The crop produces a poorer yield with that pesticide than the field has produced in other years, and also poorer than others that used a more costly pesticide. Is there negligence? The agrologist will be found negligent if the client who used the cheaper pesticide based on the agrologist's advice can prove, first, the advice the agrologist provided to use the cheaper pesticide was somehow untrue, inaccurate, or misleading. Secondly, an ordinarily competent agrologist would not have recommended that pesticide. Thirdly, the client relied on the advice in using the pesticide, and it was reasonable for the client to do so. And finally, the poor yield arose from the use of that cheaper pesticide, that is to say, causation. Proving and defending negligence claims can be very costly. It's often difficult for a judge to determine whether a professional has met the standard of a reasonably competent professional in rendering advice or providing professional services. For that reason, the parties often have to call experts, other members of the profession, to provide expert evidence on what the proper standard of care was and whether or not the defendant failed to meet it. The judge is often faced with a situation where both parties, the plaintiff and the defendant, bring in experts who say completely contrary things, and the judge is left to determine whose expert evidence he or she is most comfortable relying on. Causation can also be very difficult to prove, to determine whether the harm actually arose from the professional's breach of standard of care. Finally, damages can be difficult to quantify, particularly if they're intangible. For example, if someone's alleging a loss of reputation, or the damages have not yet been realized, for example, where there's a claim of a loss of future profits. Let me take you to some actual court cases involving negligence claims to illustrate these principles. The Baumgartner case from 1997 Manitoba Court of Appeal is one of the few cases involving a negligence claim against agrologists. That should provide you some comfort. There's many cases involving lawyers and doctors. In the Baumgartner case, a farmer who had immigrated from Germany had retained an agrologist to prepare an agrology report on the viability of a proposed cattle ranch in Manitoba in order to obtain an immigration visa. So he was trying to obtain an immigration visa. He was told he'd need a feasibility report for his business. The immigration department had actually put on courses for consultants, including agrologists, on how to prepare these reports for immigration purposes. And Mr. Remus, the agrologist who was retained to provide the report, had taken the course from the immigration department. He prepared an agrology report that indicated that the farm would be viable to support a cattle ranch. The farmer ultimately received his immigration visa, proceeded to purchase the farm, and then tried to cultivate it after a prolonged drought. When the farm failed, the German farmers sued the agrologist for negligence. So let's go back to the four elements of a negligence claim. Was there a duty of care? There most certainly was, because the agrologist was retained as a professional to provide an expert report to the plaintiff. So they were in a relationship of sufficient proximity because there was a professional relationship between them. Was there a breach of the standard of care? I'm going to deal with that on the next slide. Was there harm to the plaintiff? Yes, the plaintiff was able to establish harm because the farm failed and he lost a considerable amount of money. Finally, was there causation? The court ultimately determined it wasn't necessary to make a finding of whether there was causation or not, because he found that the agrologist did not breach the standard of care. The court concluded that there was no breach of the standard of care for these reasons. The court said that the report prepared by the agrologist was accurate and it was reasonable in light of the fact that it was provided for immigration purposes, not for the purposes of immediately starting a cattle ranch. The agrologist met the standard of care of preparing a report for that limited purpose. The court said that the agrologist could not be held responsible for the impact of the drought or the farmer's decision to proceed trying to cultivate the land immediately following a prolonged drought, and that the farmer should have sought expert advice before actually starting cultivation under those climatic circumstances. So the farmer's attempt to rely on the agrology report, which he obtained for an immigration purpose, was fundamentally not reasonable. In fact, the evidence in that case was that the farmer had sent the agrology report to the immigration department and had not even kept it or seen it for many years prior to initiating this litigation. So although the agrologist certainly owed a duty of care to the farmer to take reasonable care in providing advice in the report, the court said there was no breach of the agrologist's standard of care. He prepared an appropriate report given the purpose of the report, and therefore it was not necessary to determine whether there was causation, and the negligence claim failed. In the case of Nelson and the government of Saskatchewan, in 2003 case from the Saskatchewan Queen's Bench, two farmers obtained permission from the Saskatchewan Water Corporation to use water from a lake to divert it for irrigation purposes. Provincial engineers had tested the water and determined that it was suitable for irrigation purposes, but the provincial engineers had not specifically tested it for salinity or sodicity. If they had done so, which they later did, they would have found the water was not actually suitable for irrigation, particularly for crops. When the farmers found that the irrigated soil became very hard and impermeable, they contacted the province. The engineers at the Saskatchewan Water Corporation did some further testing and discovered the high salinity content of the water, but they did not disclose the results to the two farmers. The two farmers lost a great deal of money and initiated a claim for negligence against the government of Saskatchewan. Was there a duty of care? There was. The court said there was a duty of care because the province owed a duty to the farmers to test the water properly. The farmers had gone to the government to specifically ask for authorization to divert the water to use for irrigation purposes. Was there a breach of the standard of care? Interestingly, the court said no, not with respect to the first set of tests that were performed by the engineers at Saskatchewan Water Corporation, because they did not know the precise purpose for which the farmers were going to use the water from the irrigation. They said there was the information in the farmer's application regarding the water usage was too limited. But the court said the Saskatchewan Water Corporation did breach the standard of care with respect to the second set of tests when they did the testing for salinity and sodicity, because they knew by that stage exactly what the farmers were using the water for, and they didn't disclose those results to the farmers. The third element was there harm to the plaintiffs, to the farmers. Clearly there was considerable harm because it rendered their land incapable of farming activities. Did the breach of standard of care by Saskatchewan Water Corporation cause the harm? The court said it clearly did. The court found the government negligent and liable for damages to compensate the farmers for the lost productivity of the land from the point that it realized that the water was not suitable for irrigation. And the case really underscores the importance when a court is assessing standard of care of looking at precisely what information was before the defendant at the time that they gave advice or undertook the activity that led to the resulting harm. Some other examples: in the LeBlanc and DeWitt case, a surveyor was found negligent for failing to check the accuracy of information that turned out to be inaccurate on a survey plan he certified as accurate. It was one of those old land title descriptions that was in meets and bounds, and the actual boundary of the lot in question was half a mile away from where it was depicted in the survey plan. The surveyor relied on information from third parties without doing his own checking, produced a survey plan, and then certified it to be accurate. It caused a great deal of loss when down the road the property was sold to a number of different parties over the years. Buildings were put on property that was a part of the lot, and it all came back to haunt the surveyor for not demonstrating the proper standard of care and ensuring that the plan was accurate and certifiable. Similarly, in Allen Farms and Oliver Industrial, another case in a different context where an irrigation installer was found to be negligent for the manner in which he installed an irrigation system. The court found that the irrigation installer should have been able to foresee that the pipes would collapse with the weight of the clay backfill that was put over them. It was an irrigation system worth $1.4 million, so there's a significant amount of money at stake. But it's an example of how failure in designing a system, whatever type of system it is, can lead to substantial losses. Looking at a medical context, in the Kelly and Lundgaard decision, a woman was in a terrible car accident and had surgery. Her doctor reported to the insurance company sometime later that she would make a full recovery, except for a small risk of bowel obstruction. The doctor, it turned out that the patient, the woman who was in the car accident, was infertile. And the doctor argued that the statement that she would make a full recovery except for a small risk of bowel obstruction was not inaccurate, untrue, or misleading because it was implicit. The court disagreed that infertility was in any way implicit in the caveat that the doctor had provided, and said that an ordinary reader would assume full recovery meant full recovery and that there would be no risk of infertility. In the Harella and Powell case, it's a typical situation where real estate agents make claims about properties that they're selling, and purchasers rely on those claims and they turn out not to be true. So in this case, the purchaser sued a real estate agent who sold them a lot. They claimed reliance on the agent's expertise when he told them that they could build a 3-bedroom, 2-bedroom home on the lot. And it turned out that the setback requirements precluded a house of this size. They could only build a smaller house. And the court held that it was reasonable for the purchasers to rely on the agent because he had held himself out as knowing what could be built on the lot. So one of my key points at the end of this presentation will be stick within the scope of your expertise. When you offer statements beyond the scope of your expertise and they turn out to be wrong, you're opening yourself up for potential liability for a negligence claim. So I want to turn to the defenses to a negligence claim. And let me start by saying that someone who is sued can always lead evidence to show that they did not owe a duty of care, so they weren't in a position of reasonable proximity, that it was too remote a relationship to foreseeably expect that one's actions would affect the plaintiff. They can try and establish that there was no breach of the standard of care, so that often is the case for professionals. They acknowledge that there's a duty of care, but they allege that they didn't breach the standard of care. They met the standard of a reasonably knowledgeable, experienced professional. They can argue that there's no harm, or they can argue that there's no causal link between any alleged breach of standard of care and the harm that was suffered. So the standard of proof is on the plaintiff to establish all 4 elements, but in a negligence claim, the defendant or the defendant's counsel will be attacking all 4 of those elements, or some of those elements, to try and establish that there isn't sufficient proof to make a finding against them. In addition to arguing that the plaintiff hasn't met all of the elements of a negligence claim, however, there's also 3 specific defenses that courts have recognized in negligence claims that can either eliminate or at least reduce the portion of the defendant's liability. And those 3 defenses are, first, the volente non fit injuria defense. To a willing person, no injury is done. Secondly, the ex turpi causa defense. Action does not arise from a dishonorable cause. And finally, contributory negligence. The first 2 defenses, volente non fit injuria and ex turpi causa, are very difficult to establish. The claim of contributory negligence arises very frequently. So let me turn to the first of those defenses, the volente defense. To a willing person, no injury is done. The courts have established a principle that where a plaintiff is harmed, but they've voluntarily agreed to undertake some level of risk in the activity in which the negligence is claimed, the claim may be defeated or the damages reduced significantly. For example, a passenger who accepts a ride from a friend, knowing that the friend doesn't have a license and cannot drive, and is then subsequently injured in an accident caused by the friend's negligent driving, may have his negligence claim defeated altogether, or or his damages reduced because he voluntarily assumed the risk of being driven by an incompetent driver. More commonly, people will get into a car with someone who's driving who they know may be somewhat impaired. Certainly, if you know that the driver is impaired, you're voluntarily assuming some level of risk that they may not be safe to drive. Let me give you some examples. In the Berenson and Ontario case, a farmer claimed that the province of Ontario was negligent because it had dumped road building waste material on the property that he later purchased. The waste material, it was from road construction, had actually been dumped on the property in the 1960s. The original owner of the farmer accepted it, although didn't realize that it had possible toxicity. A toxic substance in the material ultimately contaminated the well water and caused terrible effects for the cattle on the farmer's land. The province at the trial level raised the Volente defense, arguing that the farmer voluntarily assumed the risks of this toxicity of whatever was buried on the property when he bought the property. The court did not accept that claim. At trial, the court found that the province had not disclosed the potential toxicity to the previous owner at the time that he consented to the dumping of the material on his property. So the previous owner certainly did not voluntarily assume the risk of toxicity. And moreover, the farmer who subsequently bought the farm had made reasonable inquiries when he bought the farm and was told that road waste was buried on it. If a person does not know about a danger, he or she ultimately cannot voluntarily assume the risk of that danger. Although the farmer who bought the farm later on noticed some pieces of concrete and other substances, he was told it was from an old building that had been burned down. He wasn't aware that there was former road fill buried on the property. At trial, the court didn't allow the province to raise the Volente offense. The case actually went to the Court of Appeal, and the Ontario Court of Appeal found that at the time, the standard of care was not to regulate the dumping of these substances, and the province didn't know there was any toxicity, so ultimately the farmer did not succeed. But I wanted to raise this example as a clear example of the application of an attempted application of the Volente defense, which shows that if you don't know what the risk is, that defense can't be raised against you. The ex turpi causa defense, action does not arise from a dishonorable cause, is a defense, a common law principle that courts developed because they didn't want to be perceived to be helping individuals who were injured or suffered loss as a result of immoral conduct or illegal conduct. And what constitutes immoral conduct has certainly changed and evolved over the years, but most of the claims of ex turpi causa are premised on claims that the plaintiff was involved in illegal conduct at the time that they sustained an injury or loss. So if the plaintiff was involved in a criminal act at the time of the sustaining an injury as a result of the defendant's negligence, the plaintiff will be denied relief. For example, if a person driving the getaway car from a bank robbery negligently crashes it, the negligence claim of a bank robber passenger against the driver will not succeed. Let me give you a couple of real-life examples. In the Baroto sports case, the plaintiffs and defendants were young men who amused themselves by making pipe bombs and exploding them. The plaintiff was injured when a pipe bomb made by the defendants exploded. The court found that all of the parties were engaged in illegal activity because having possession of pipe bombs was contrary to Section 80, then Section 80 of the Criminal Code, and therefore the defense of ex turpi causa applied, and the plaintiff could not succeed in making out his claim. In the Frank, it actually should be Funk, F-U-N-K, estate and clap case, the court held that the ex turpi causa defense did not apply to defeat a negligence claim by a woman who lost her husband after he was pulled over for impaired driving and thrown into the local jail cell. The police didn't remove the man's belt before they put him in the cell, and he used his belt to hang himself, and he died. The court found that the police were negligent in failing to check on him and failing to remove the belt. The police force tried to argue extra causa should apply because the man who killed himself was in jail, being brought in for impaired driving. And the court rejected that argument. The court rejected the argument because the widow and the children of the man who died had done nothing immoral or illegal. They were just bringing a claim for the loss of their family member. So the court wouldn't allow that defense to succeed. Let me turn to contributory negligence. That is by far and away the most common defense to a claim for negligence, where a plaintiff's fault has contributed to the damage or the injury that was sustained. Damages will be reduced in proportion to the plaintiff's level of fault. It was a concept that was initially developed at common law by judges, but is now codified in the BC Negligence Act. So, for example, a driver who's not wearing a seatbelt when another driver negligently hits him after going through a stop sign will be held to be contributorily negligent and have his damages proportionally reduced, based on the view that had the driver been wearing a seatbelt, he would have sustained less serious injuries, and he shouldn't be entitled to claim for more serious injuries if he could have taken steps to reduce his own risk. The Tanner, Hay, and Hansen case involved facts where the plaintiff claimed that the defendant accountant was negligent in preparing his tax returns. The accountant said that the plaintiff was partly at fault because he should have reviewed the returns before submitting them to Revenue Canada. The court did not allow the contributory negligence defense because the plaintiff had no accounting or tax knowledge. And the court basically found that it was a complex tax return, and the plaintiff was really relying completely on the accountant to fill in the appropriate information and calculations. In the Gauthier case, a purchaser sued a vendor and a house inspector when the house that he purchased suffered water damage because of the location of the house on the slope of the lot. It was a steep slope. The vendor had indicated in the disclosure statement that there had been problems with water in respect of the windows, but he thought he had solved them. The plaintiff didn't make any more inquiries with the vendor about that, but the plaintiff did hire a house inspector who did not warn him about the slope of the land, although one would have thought that would have been apparent. In any event, the court found that a prudent purchaser would have made further inquiries about the issue of water damage that was flagged in the property disclosure statement and reduced the plaintiff's damages by 30%. So let me just wrap up, and I come back to this at the end of the presentation. But when you're dealing with potential negligence claims, your best defense is to make sure that you meet the standard of care as a professional of a knowledgeable and experienced individual, and that you stick within the scope of your expertise. It doesn't matter if you're being paid or not. If you're giving advice and there's reliance on that advice, and it's established that the advice doesn't meet the standard of care standard, you could be sued for negligence. Let me now turn to regulatory offenses and specifically the defense of due diligence. Regulatory offenses are referred to in law as strict liability offenses. So, like criminal offenses, true criminal offenses, regulatory offenses are designed to regulate the conduct of individuals in order to protect public health, safety, or general welfare. So you've got true criminal offenses that are all set out in the Criminal Code of Canada. And then you have these strict liability offenses, which are often referred to as public welfare offenses. Unlike criminal offenses, regulatory offenses are not contained in the Criminal Code, which is federal legislation. They are contained in a broad range of regulatory statutes, which can be provincial, territorial, and or federal, such as the Forest Act, or the Environment Management Act, or the Water Act, the Forest Practices Code of British Columbia Act. While regulatory offenses prohibit conduct contrary to the public interest, they generally do not carry the same social stigma as true criminal offenses. So, in earlier years, there were only two types of offenses. One was the true criminal offense, which was called the mens rea offense, which requires proof beyond a reasonable doubt that the defendant or accused subjectively intended to commit the act and that he did carry out the act or she did carry out the act. So in true criminal offenses, the Crown always has to prove the mens rea, the mental intention to commit the act, and the actus reus, which is the physical act itself. Then there was the category of offenses called absolute liability offenses, which only require proof that the defendant or the accused committed the act, such as a parking violation. You're not going to have much luck going to parking court and arguing, I didn't intend to leave my car there after the meter ran out. Mental intent is completely irrelevant to absolute liability offenses. It's only necessary to prove that you committed the offense. Proof of commission of a strict liability offense, which is a middle type of offense, requires less proof of intention than a full mens rea, true criminal offense, but it requires more than just proving commission of the act as in an absolute liability offense. So a strict liability offense falls between the two offenses above. There's mens rea, which is the hardest to prove. Secondly, there's strict liability offense, and then thirdly, absolute liability offense. For a strict liability offense, the Crown must only prove that the defendant committed the offense beyond a reasonable doubt on a criminal standard. However, it's open for the defendant to argue that they should not be convicted because they took all reasonable steps to avoid committing the offense. And that is what is referred to as due diligence. The recognition of strict liability offenses came out of a case in 1978 called Regina versus Sault Ste. Marie, which went all the way up to the Supreme Court of Canada. In that case, the city was charged with an offense under the Provincial Water Resources Act because it had retained an independent contractor who had ended up discharging material that landed into a creek that fed into a river that turned out to be deleterious. The Crown proved that the pollution was discharged, so there was no question about the actus reus. On appeal, though, the Supreme Court of Canada held that requiring the Crown to prove mens rea, the intent to pollute, was too onerous for the Crown, that this was more a public welfare issue, and that requiring no intentional element was too harsh because the city might have been morally innocent, had no intention to pollute, which in fact they didn't. So what the court did was craft a middle category of offense called the strict liability offense, in which proof of commission of the offense of prohibited conduct is not an offense if the accused can demonstrate due diligence. In Sault Ste. Marie, the court directed a new trial, so after going all the way up to the Supreme Court of Canada, it went back to a trial court. The city had the opportunity to prove that it exercised due diligence and took all reasonable steps to avoid discharging pollution. The usual penalty for a regulatory offense is a fine. However, penalties can be more severe and can include imprisonment and other sanctions. What one generally sees is the nature of the penalty is commensurate with the level of risk or perceived risk to the public welfare. So, for example, Section 120 of the Environment Management So let me backtrack. So the sanction is usually commensurate with the level of risk to public welfare. So, for example, Section 120 of the Environmental Management Act establishes different penalties for different offenses created under various sections of the Act. In part, it says a person who contravenes Section 12, littering, Section 13, discharge of waste from recreational vehicles, commits an offense and is liable to conviction to a fine not exceeding $2,000 or imprisonment of not more than 6 months, or both. But Section 120 sub 2 provides a person who contravenes any of the following commits an offense and is liable to conviction to a fine not exceeding $200,000 or imprisonment for not more than 6 months, or both. So a significant increase of the fine from $2,000 to $200,000 when it relates to breach of Section 9.3, hazardous waste storage and disposal, Section 10, transportation of hazardous waste, Section 11, provisions dealing with packaging, product containers, and disposable products, Section 72, control of air contaminants, Section 79, dealing with spill prevention and reporting, Section 131, dealing with confidentiality, and regulations dealing with vehicle and engine emissions. Proving the defense of due diligence involves either one of two things. Either the accused can argue that they mistakenly believed in a set of facts that, if true, would have meant that the conduct was not illegal, or alternatively, that the accused took all reasonable steps to avoid the prohibited conduct. If a person has acted with reasonable care or diligence, if they've avoided all of the reasonably foreseeable harmful or prohibited consequences of their actions. So I want to underscore the words reasonable, foreseeable, because as I go through the cases, that's a theme that comes up time and again. The reasonableness of the steps taken to avoid the prohibited conduct is assessed by looking at the circumstances at the time, not with the benefit of hindsight. So let me give you some true case examples. In McMillan-Blodell, the forest company was charged with a regulatory offense when its pipes leaked some diesel oil near the Queen Charlotte Islands. It was argued that there was an unforeseen microbiological process that had caused the company's pipes to corrode rapidly due to soil disturbance, and that led to a toxic substance into the water. The company knew its pipes were aging, but claimed that it inspected them regularly, and a recent inspection had shown that the pipes were sound. The company was charged with an environmental offense, a strict liability offense. The pipes actually had been, this case is about 10 years old, the pipes had actually been installed in the 1960s, and the company had reports that they had a limited life, and they were coming to the end of their life. The trial court accepted that the company honestly believed that the pipes were sound, and they accepted that the cause of the leak was not reasonably foreseeable because it was unknown, this phenomenon of this microbiological process. But ultimately, the court rejected the defense of due diligence because McMillan-Blodell should have known that the pipes had a limited life, and they didn't take all steps possible to prevent a leak from occurring because of the aging pipes. The Regina versus Emile K. Fishing Corporation case involved a commercial fishing company that was fishing and caught bycatch, which is retention of prohibited species of sockeye and coho. They kept 12 fish, combination of sockeye and coho, which was bycatch. They had no licenses to catch sockeye and coho at the time they were fishing. The company was charged with a regulatory offense, a strict liability offense under the Fisheries Act for having an unreasonable amount of bycatch. The fishing company argued that although it had exceeded the allowable bycatch, it had exercised due diligence and should not be found liable. And the court accepted the defense in that case. The court found that the fishing company, by equipping the vessel with the proper equipment to segregate the fish, to be able to separate the bycatch and return it to the ocean, and by exercising reasonable care and hiring an experienced and competent skipper and crew, and instructing the crew, the skipper and crew, specifically to comply with the Fisheries Act, the company had exercised due diligence. So this is a case, a good example to illustrate where the offense arises through the conduct of an independent contractor or an employee. The company or the person that hired the employee or the independent contractor will have to show due diligence in terms of showing that they were properly equipped, they were properly qualified, they were properly instructed. In some cases, they'll have to show that they were properly supervised. In terms of reasonable and honest belief in a set of facts, a good example is the Regina versus Tavares case, a 1996 case where the captain of a fishing vessel was charged under the Fisheries Act with a strict liability offense. He was fishing in the North Atlantic Fisheries Organization convention areas without a registration card, a license, and proper authorization from Canadian fisheries authorities. He argued that he should not be found guilty as he held a honest and reasonable belief that the vessel was actually registered in Panama and therefore not subject to the convention, and that he didn't need authority from Canadian fishing authorities. He believed the vessel was Panamanian and that he had a license from Portugal to fish under a foreign flag. Well, the court found that the vessel was actually registered in Canada, that it was reasonable for this individual, the captain, to rely on the Panamanian documents that were on the vessel without requiring proof from his employer that the vessel was not Canadian. So the court held that he had a reasonable and honest belief based on information provided by his employer, the owner of the ship, and by virtue of the Panamanian documents that were on the vessel, that he didn't need specific Canadian authorization to fish what he was fishing. In the Pope and Talbot case, this was in another context, forestry, logging, the defendant forest company's subcontractor clear-cut an area in a cut block that was to be selectively logged. So they clear-cut the whole cut block when they should have done much more selective logging in it. The defendant forest company was charged with contravening the Silviculture Prescription and Section 67 of the Forest Practices Code of British Columbia Act. It was a strict liability offense. The forest company argued it had exercised due diligence and attributed all of the error to the fault of the subcontractor. The matter went to the Forest Appeals Commission, which found the forest company liable, and the forest company then challenged that decision to BC Supreme Court. The court agreed with the Forest Appeal Commission's finding that it was reasonably foreseeable that it would be difficult to recognize the boundaries within the cut block of the areas that could be clear-cut and the areas that should have been selectively logged. And ultimately that the defendant forest company failed to exercise due diligence because it should have made significantly more effort to mark out the proper limits of what could be clear-cut and what could be selectively logged, and should have focused more on what the subcontractor was doing. In effect, left too much discretion to the subcontractor to go out there and do the logging without enough direction. Another example of a due diligence case in a different context again is the Regina versus Barr case, and that was the terrible forest fires a few years ago in the Okanagan. Mr. Barr was charged with unlawfully dropping a lit cigarette butt within 1 kilometer of a forest, contrary to Section 87.1 of the Forest Practices Code, which I've reproduced in the slide. It said, except for the purpose of starting a fire in accordance with this act, a person must not drop a burning substance in or within 1 kilometer of a forest. Mr. Barr claimed that he had exercised due diligence because he was a lifelong smoker who had a routine for extinguishing cigarettes. He explained that he would drop the butt on the ground and twist it underneath his foot to ensure that the nicotine was dispersed and was not lit, and that he followed that routine in a reasonable and prudent manner on that day. He admitted that it was very hot and dry when he smoked his cigarette that day. He went up on a hill with someone looking to where to locate a satellite dish, and he acknowledged dropping his cigarette, and he said he put it out with his foot, as he always did, But he also acknowledged that a fire broke out within minutes of his dropping the cigarette within the precise area where he had dropped it. And the court rejected Mr. Barr's due diligence defense. The court said that Mr. Barr did not exercise due diligence because he had not established he had taken reasonable steps to put out the cigarette, particularly in those circumstances where he was in a very hot area where there was a lot of dry tinder and pine needles around the area. So the court just rejected his defense and said he didn't take enough care. And it was, of course, a catastrophic fire. In Pacifica Papers, this was another case involving the Fisheries Act. The company, Mill, was charged with depositing or allowing to be deposited a deleterious substance in an area known to be frequented by fish, contrary to the Fisheries Act. And this was a case where the court accepted the defense of due diligence from the company. The company had hired an appropriate contractor and had given the contractor instructions. Then, contrary to its instructions, the contractor changed the location of a hose, and some material ended up finding its way into a creek and into a river. But the court accepted that the company itself had acted in a diligent manner because it had hired a responsible and qualified contractor. It provided clear instructions to the contractor to pump water from an excavation onto an adjacent rock pile and not into a stream. It had no reason to believe that its instructions would not be complied with by the contractor, and the court also said it was not reasonable to expect the forest company's supervisor to remain on site throughout the process, given that they had hired a responsible contractor, given very clear instructions, and had no reason to believe that those instructions would not be followed. Another Fisheries Act case, BHP Diamonds, the company was charged under that act because sediment entered into a lake during the construction of a diversion channel for its mining operations. The court, the sediment went into the diversion channel because permafrost had melted. The court found that it was not reasonably foreseeable that the permafrost in the area not immediately adjacent to the channel would thaw and cause movement of sediment into the channel. It held that the company had acted reasonably in developing the diversion ditch and could not have taken precautionary steps against that which was not foreseen. So, although the theme of was it reasonably foreseeable permeates all of these cases on due diligence, courts will be mindful that that parties cannot take steps to prevent harm if the action is simply not foreseeable in any way. Warehouser Canada Limited, another case where the forest company was charged under the Forestry Act when road washout entered a creek. The court considered the following factors in assessing the reasonableness of the company's actions. They looked at a preventative system that Warehouser had implemented in place to monitor the conditions of the road. They sent out inspectors when the forestry roads were passable, and they also used helicopters in the winter to fly over the roads when the roads became impassable with snow. When it was reported that there was a cut in one of the roads, the court looked at the efforts that Warehouser made to address that cut and how promptly they responded to that problem. They looked at industry standards for maintaining these types of forestry logging roads. They looked at issues that were beyond the control of the company. There was some suggestion in that case that permits had been given to other companies for other work in the vicinity, which may have also led to some of the issues with the road washout, and the foreseeability of the road washout entering the creek. The court ultimately concluded that Warehouser had acted with due diligence and demonstrated reasonable care by implementing a preventative road maintenance system and inspection schedule and following it. And the case really underscores as well how important it is to document all those sorts of systems so that if there is a case that's brought against you for a strict liability offense, you're able to provide documentation to show all the steps that you took to prevent possible harm. Whether or not a defendant has acted with reasonable care is assessed in light of the circumstances at the relevant time. It's courts try to be mindful about not looking at it with the hindsight, with 2020 hindsight. So the standard is reasonableness, is not perfection. So relevant considerations for the court will include the severity of the potential harm. More care is required for more serious potential harm. So the greater the seriousness of the harm, the more steps should be taken to ensure that nothing happens. The likelihood or probability of harm arising. Again, the more probable the harm, the more care that courts will expect defendants to take to ensure that nothing bad happens. Whether there were reasonable alternatives that the accused knew or ought to have known to avoid or minimize the harm. This really harkens back to sort of standards of care and what should the defendant have been aware of in terms of methodologies to minimize or avoid harm. The degree of control that the accused or defendant had over the events. For example, we've gone through cases where companies hired qualified independent contractors and gave them clear instructions. The fishing vessel one is a good example where the owners of fishing vessels can't be expected to supervise what their fishermen are doing in the middle of the ocean. Whether the defendant acted according to industry standards, including keeping abreast of technological or other changes, and hired appropriate consultants and experts. And I would also add, did they supervise appropriately? And whether the defendant was aware of changing conditions and responded to them in a timely and appropriate manner. If the alleged breach of a regulatory statute involves conduct by a professional, it will be necessary to establish that the persons associated with the activity were properly qualified for the task that they were undertaking and that proper methods were employed to carry out that task. And I would also add that the people carrying out the task were properly equipped with the right equipment. The defense of due diligence, though created by common law, as I said, is now codified in many regulatory statutes. And so these are the types of considerations that you should keep in mind. I've given you some examples in the following slides of regulatory offenses that expressly recognize due diligence defenses. For example, 72 of the Forest and Range Practices Act says that for the purposes of the determination of the minister under 71 or 74, no person may be found to have contravened a provision of the Act if the person establishes that the person exercised due diligence to prevent the contravention, the person reasonably believed in the existence of facts that, if true, would establish that the person did not contravene the provision, or the person's actions relevant to the provision were the result of an officially induced error. Similarly, in the Section 27 of the Integrated Pest Management Act, Section 21 states that if a corporation commits an offense under this Act, an employee, officer, director, or agent who is authorized, permitted, or acquiesced in the offense commits the offense. And that sub 2, in prosecution for an offense, it is sufficient proof of the offense to establish that the offense was committed, and so on, unless the accused establishes that the offense was committed without the accused's knowledge or consent, or that the accused exercised all due diligence to prevent the commission of an offense. So I want to end with some takeaway points for you on how you can minimize the risk of potential liability of both types. Negligence claims, including claims of negligent misrepresentation, and being prosecuted for a regulatory strict liability offense under a provincial, federal, or territorial statute. First and foremost, know and comply with your own regulatory framework that governs your profession. In your case, be familiar with and comply with your bylaws, including your code of ethics, as well as any other statutes that are relevant to your practice. Stay within the scope of your practice. Do not offer advice or assistance on areas beyond the scope of your expertise. As I pointed out earlier, if you do provide advice on something that's beyond the scope of your expertise, and a person relies on that advice to their detriment, they may have a claim in negligence against you. Consult with other specialists. If it's an area that requires a high level of expertise, if it's outside your area, or even if it's not, and you would benefit from having another set of eyes look at it, consult freely with other specialists. I certainly find in my field, I often receive calls from other lawyers wanting to run things by me, and I do the same. I call my colleagues as well. So I really encourage you to keep up those networks of professional contacts and to run things by people that you work in the same field as you. Stay abreast of changes in technology, regulation, and practices through regular continuing education and certainly professional development. Always ensure that the professionalism, the level of your work is not compromised by time or budgetary constraints. And I know that's easy to say and not always easy to follow through on, but if you are asked to provide a rush opinion or a rush advice, as we all often are, and you provide that advice without doing all of the homework that you should have done, and that advice leads to some loss on the part of the person that requested it, you could be potentially liable for a claim. So use appropriate language indicating within the time constraints that I have, here is my preliminary view, but if you want a more fulsome opinion, I'll require more time and I'll have to do this additional work. Be very clear on the scope of your retainer, what you've been asked to do and what you can do within the constraints that have been provided to you. Properly train and supervise your staff. If you're delegating some of your authority to your staff, you've got to supervise and make sure that they're carrying out those functions properly, because you will ultimately be responsible for their work. You're the one who's signing off on the report or on the advice. Create complete and legible field notes, and always, always, always document your reasoning process. Whenever a matter goes to litigation, courts place heavy reliance on documentation made contemporaneously at the time that the work was being undertaken or that the activity at issue was being undertaken, because all those notes, documents were created before there was any issue of litigation being on the table. So courts feel very comfortable placing a lot of reliance on notes, field notes and reports made at the time. And the more fulsome and the more complete your notes, your field notes, the better position you'll be in to defend your actions in the event that you face a negligence claim or you're charged with a regulatory offense. Adopt standard operating procedures so that you can demonstrate that you've always followed necessary steps. And let me give you an example in my field, because we often witness affidavits. And I remember one of my mentors telling me when I started practicing law, when you take someone's affidavit, always ask them, have you read the affidavit and do you swear or affirm the contents to be true? And if you always do that, if a question ever comes up years later, did you actually ask the person if they read the affidavit and swear it to be true, you probably won't remember witnessing that one person's affidavit. But you can say to a court, I always do this every time I witness someone's signature on an affidavit. So it's an example of, although you can't be expected to remember every encounter with every individual that you deal with in your professional life, if you establish some standard operating procedures that when your conduct is called into question, you can say to a court, this is what I do invariably in every circumstance. That type of evidence will carry a great deal of weight. Use checklists if possible to ensure that you've completed all of the tasks and you haven't missed anything. And checklists are also a useful evidentiary tool too in the event that you have to defend your actions later on. Maintain proper records, including emails, non-transitory emails that contain any substantive information, correspondence, notes of discussions, memos to file, instructions are critical. And it's not only necessary to keep final copies of reports, but you should keep the supporting material on which your opinions were based, subject to Of course, any record management policies under Freedom of Information Protection and Privacy if you work for a public body, or you also have to be mindful of the Personal Information Protection Act if you're an organization in the private sector. But when you do keep reports, if at all possible, keep the supporting data, keep the supporting documentation so that you can recreate and demonstrate for court, if necessary, how you reached the opinion that you did. Ensure that the level of effort that you expend is commensurate with the perceived risks. If you're asked to give an opinion on a matter that has significant risks, significant potential for significant loss for parties, make sure you put a lot of effort into that opinion. I'm not saying don't put a lot of effort into something just because the risk isn't small. You should always meet a certain standard of conduct. But if there is a matter that you're being retained on that involves a potentially significant amount of money, significant risk, keep that in mind when you're working on a retainer. Preserve documents for as long as legally required. As of last year, we have a new limitation act in this province, and with subject to some limited exceptions, a civil claim for negligence cannot be made after 15 years from the date on which the event giving rise to the claim occurred. So from the date the new limitation act came into force, you'll want to keep documents for 15 years. It's a bit of a hardship, but it ultimately will be to protect you. In terms of client relations, always try and be clear on the scope of what you're being asked to do and document it. Follow it up in writing, whether it's an email or a letter or a memo, whatever, but be very clear on what it is you're being asked to do and to make note of it, because confusion can step in, particularly if things go awry and you end up in litigation with your client, and suddenly parties may have different perceptions of what the retainer involved and what the professional was expected to do. So very important to document what is it exactly you were asked to get. Remember the case of the German farmer. The agrologist was only asked to provide a report for immigration purposes, not on whether it was feasible to start a cattle ranch at that point in time. Use contracts that clearly outline the responsibilities of each party. Properly drafted agreements can prevent misinterpretations and misunderstandings and unwarranted assumptions, but only if they're properly written. A poorly drafted contract can certainly foster misinterpretation, misunderstandings. I think the bottom line is the best contract in the world isn't going to save a relationship if it's doomed, if there's mistrust between the parties right from the outset. But certainly having a properly drafted contract can be of considerable help in defending yourself against a breach of contract. It won't help you likely in relation to negligence claim, but certainly for breach of contract. Be aware that you can be sued for negligence even if you're not formally retained as a professional or paid. A court will look at the entire context of the circumstances to determine the reasonableness of a plaintiff's reliance on your advice or representations. Always recommend to clients in writing, preferably, that they seek opinions from other professionals if part of the work is outside the scope of your expertise. In terms of drafting opinions and reports, it's important to properly qualify the opinions that you provide, identify the areas that you have not directly investigated, and explain why you've not done so. Document in your opinions areas that require further investigation, and perhaps even recommend who should undertake such investigation. Document in your report what factors you considered, particularly where you decide not to undertake certain procedures or tests, to ensure that you can defend that decision if it's challenged at a later date. Reference and explain, justify any new or unusual methodology that you've used. Identify and, if possible, address uncertainties or differences of professional opinion. And let's face it, so much of what all professionals do can be subject to debate amongst reasonable people. So, and particularly if you're providing an expert report for court, you should also be aware that you're not there as an advocate. You're there to help the court understand the facts. And it's not very persuasive when professionals are retained as experts to give expert evidence and won't fairly concede that other reasonable opinions may exist. State your conclusions in your report clearly and unambiguously so that they can be readily understood by all readers, not just a client who may be very sophisticated and understand all of the terminology. But if things go awry, regulators will be reading the report, or a court, a judge who has absolutely no background in agrology may be reading the report. So when you're drafting your report, have the foresight to draft it in such a way that anyone could pick it up and with pretty minimal effort understand what you're talking about. Include in your conclusions any appropriate qualifications or caveats and recommendations for additional inquiries or referrals to other experts if you consider that appropriate. When you're providing a professional report, ensure that you outline the description of the purpose of the report and specifically what you're being asked to do. Outline briefly your qualifications. That will help in the context of establishing that if a plaintiff tries to rely on you for some other purpose, that showing that perhaps that reliance wasn't reasonable given what your qualifications were that you clearly laid out in the report. Outline your references and sources of information. Outline the assumptions that you used in formulating your opinions. Provide a detailed description of your testing methodology and discuss the standards that you used and followed in reaching the opinion or giving the advice that you gave. Finally, just to wrap up, some final thoughts. Again, negligence is a common law principle developed by courts that requires everyone to take reasonable care not to harm others, whether you're a professional or not. And it's not to harm others who may be in reasonable proximity to you, people that it would be reasonably foreseeable to conclude your actions could affect. A finding of negligence can lead to a court awarding the person who suffers loss or injury compensation for any harm or injury suffered. The main defenses to a negligence claim are to argue that there's no duty of care, there's no breach of the standard of care, the plaintiff suffered no harm, or there's no causation. Finally, on strict liability offenses, courts are only the Crown is only required to prove that the defendant committed the offense, but it's still open for the defendant to avoid a conviction by showing that he or she took all reasonable steps to avoid committing the offense, or in other words, that he or she or it, its corporation, exercised due diligence. The standard is reasonableness, not perfection. Ask yourself, what would a reasonable agrologist do in these circumstances? That concludes the overview of the negligence and strict liability principles. I hope this will be helpful to you in your professional work. And if you do have specific questions, I know you can send them in through the Institute office, and I certainly will respond as quickly as I can. Thank you very much.